On Law Weekly today, we'll look a little closer at the recent Supreme Court judgment nullifying the trial of Ude Udeogu, a former finance director in the Abia State Government House, and by implication that of the former governor of the state, Orji Uzor-Kalu. What will be the implication of that decision on other judgments delivered by the same judge around the same period? We have the views of the lead prosecuting counsel, Rotimi Jacobs, SAN. Also showing on the program, an international perspective on virtual court proceedings from an immigration judge in Canada, Dr. Ayodele Akeroye, plus the criticisms trailing the shortlist of lawyers approved by the NJC for appointments as judges for different courts across the country. That's our lineup on this episode of the program. Hello and welcome. I'm Shola Chieli. My guest, Senior Advocate of Nigeria, Rotimi Jacobs, is the foremost prosecutor for the Economic and Financial Crimes Commission, EFCC. For 13 years, he prosecuted the criminal case against the former governor of Abia State, Orji Kalu, all the way from the trial court to the Supreme Court. Against the background of some criticism trailing the recent Supreme Court judgment nullifying the trial by Justice Mohammed Idris after his elevation to the Court of Appeal, I began this interview by getting his views on that judgment.
Well, you remember this, the charge was filed in 2007 and is basically on the administration of Uzor-Kalu, who was the governor of Abia State between 1999 and 2007. So it was alleged that there were government funds in government house were taken to the banks and obtained drafts in the name of a bank. And those drafts were brought to Lagos, and those drafts were cleared by the banks in Lagos and paid into the account of Slok Nigeria Limited, his company, for his own benefit. And this fund runs to several billion, it was 7.2 billion. So, and we filed a simple charge that time. You know, a lot of controversy as to why should you file an action. There's no prima facie case. There was an order made by Abia State High Court that we should not go, we should not proceed against him, we should not arrest him. No, and
that the offense was committed in Abia. Why come to Lagos?
So
to file
all
the
those
charge?
controversies, they challenged the charges, and the court, High Court, Justice Bello, who is now a member of ICPC, was the one who sat over the case and ruled that the file was properly filed. They appealed from 2007. We were at the Court of Appeal. The judgment was also against him, and up to Supreme Court in 2016. That was when the Supreme Court decided the case and said the charges were proper and that he should face his charge, and that his company, there are sufficient evidence to show that his company took this money, so that he should go and defend himself. The prosecution should push his case, and whatever defense he has, he should go and place it before the High Court. So that is why we, in 2016, but luckily for us, in 2015, there was Administration of Criminal Justice Act that abolished all these proceedings, preliminary objection.
That makes the case drag all the way.
So within 3 years, we were able to call 19 witnesses. It has never been like that before. So within that 3 years, we were able to conclude our case. And then after the prosecution closed his case, he raised a no-case submission, stating the same argument before, that there is no prima facie case.
Both defendants now?
All the three defendants.
His company,
Udeogu, who was the director of finance in government house, who procured those drafts, also appealed. So at the Court of Appeal, then as his lordship finished the proceedings, took all the prosecution's case, he ordered that we should write written address on no case submission. Then before ruling could be given on no case submission, his lordship was elevated
to the Court of Appeal.
To the Court of Appeal. Now, it was Orji Uzor-Kalu, for himself and on behalf of his company, wrote to the President of the Court of Appeal saying that, well, with the Administration of Criminal Justice Act, prosecution has closed his case, and we are at the stage of ruling on no case submission. So why don't you give permission to Justice Idris to come to the lower court and conclude this case? So,
which the relevant provision of the Administration of Criminal Justice
Section
Act
396, subsection 7. Aja. So, and the president of Court of Appeal agreed with him and granted the fiat to Honorable Justice Idris to come down to the High Court to conclude this case. So everybody, we did not apply. The prosecutor did not apply, but we couldn't afford. Then before we started, I asked all the parties. I said, my lord, this application was made by the first defendant through his counsel, and this is a copy of the application. His lordship said there is a copy also in the file. Now, what is the position of the other defendant? All of them said no. It was written on with their permission that they agree and that the matter should be allowed to be concluded. But to their shock, his lordship ruled and
dismissed the
no case submission. That was when this tactics started. Then after that, Michael Zekome came to the court and said no, on behalf of the Uzor-Kalu, the first defendant, and raised the objection. I said, how can you challenging the appearance of the judge when you are the one that applied under the AJA in order to ensure speedy trial? That is the reason why we have all those provisions, that once a judge starts a case and the prosecution has started his case, he must be allowed to conclude his case. So, like the provision of section 129 of AJA that allows, once a judge starts the trial of a criminal case, the chief judge cannot transfer that case arbitrarily from him. Once you have started calling witnesses, he cannot transfer it. Lawa's case, the Court of Appeal construe it and say, yes, it is proper. You cannot allow cases to be transferred like that once he has started. So the spirit is that there must be the criminal cases must be expeditiously hard. But this one, we should not hang Supreme Court for ruling against us on this.
No, but what happened?
The Supreme Court based their decision on section 253 of the Constitution that says that the Federal High Court shall be properly constituted if it consists of at least one judge of that court.
The Federal High Court.
And that court is the Federal High Court. They are saying, as at the date Justice Idris gave his decision, is no longer a judge of the Federal High Court. So that's the position of the Supreme Court, and that was the previous position in Obuya and Okudo and the other case which the appellant also rely on. What they are saying is that once you are no longer a judge of that court, the court is not properly constituted. That is the backbone of that decision, and I think that decision is the right interpretation of that section, and the way out is to amend that section to allow that it shall be properly constituted by a judge of that high court, or a judge as permitted, or former judge that have been permitted to sit as a judge of that federal high court by an act of National Assembly or an act of the state in the equivalent section regarding to state high court. So it's constitutional amendment that is required.
Would it have made any difference if the fears had come from the CJN?
It will even be worse, because the Court of Appeal justice is not directly under the CJN, and neither can it also be issued by the CJ of the Federal High Court. So it will not make any difference. The proper way to do it is make the National Assembly, persuade the National Assembly, work on the National Assembly to amend the Constitution. These provisions is not alien, is not new. It's been with almost all Commonwealth countries, but they put their laws in a proper perspective. In Ghana here, it is permitted. The judges who have been elevated are always allowed to finish his pattern matters. So I think we can still do that, amend the Constitution, and then allow the judges to finish their cases. Or if without even constitutional amendment, there are things you can do now. Once you know you want to appoint somebody, you give him a time before he takes the oath of office. Give him 6 months. Finish your pattern matters before we announce you, or before you take your oath as a justice of Court of Appeal. So it can be done.
So how soon is the EFCC gearing up for the prosecution, fresh prosecution of the case?
Well, as I said, the matter is, the evidence is overwhelming. None of them is contesting the facts. So I've been saying it, and I will continue to say it, that the truth, there's nothing you do to the truth that it will not survive. So the witnesses, some of them are saying, the cases have, most of our witnesses are coming from the banks. Most of these banks have and were no longer existent, like Standard Bank, like iBank, or what do they call it, Inland Bank. They are no longer there.
So how easy is it going to be to conduct fresh proceedings for this case?
But the documents are there. The documents are there, and the bank that inherited them will always call them to come and produce the document which they inherited. So
when they were not the makers of the document.
Yeah, so those are the areas where the issues will come in. But they will always be making the issues, but we will meet the issues whenever they make.
When are we likely to see the fresh arraignments?
Well, that will depend on the step taken by the appellant, because the first defendant is still at the Court of Appeal. His appeal is still pending. Also the third defendant is also at the Court of Appeal. So whatever decision they make, but we will move the court. We will apply to the court formally that the matter will start against the second defendant that appeal.
But now this Supreme Court judgment, it has several implications on some cases, especially concluded ones, also by the same Justice Mohammed Idris. And I'm talking about the case of former Governor Rashid Ladoja, former Special Senior Assistant to the former President Goodluck Jonathan Dudafa, whose cases were also handled by this same Justice Idris. What will be the implication on those cases? It's a
double-edged sword. So it's for us, and it's against us. So it's against the prosecution, and it's for the prosecution. Some of the defendants have been discharged, because I know majority of those judgments you mentioned were for the defendants.
Yes.
So which means those judgments are also nullity.
Finally, I want you to talk to us about this introduction of virtual proceedings in our courtrooms. Do you think that it will help to speed up, especially EFCC cases?
Well, it's not new. ACJA has also done good provisions in ACJA that allow video recording of proceedings, video taking of, when you go to witness protection sections. So there are ample provisions there that allow even witnesses to give evidence in his home. If you think that you need to protect that kind of witness. So we have done it even in, I remember in a case involving one governor, a witness was in London, and we summoned him. He was not in Nigeria, he was not eager to come to Nigeria. His proceedings were taken under ACJA by visual recording through electronic means. So, and it was very smooth. The other side were able to cross-examine him also. So, but some people are saying that we may have problem in most of those areas, that we may not be able to, particularly when that witness is to tender evidence, when it's to tender document. How do you handle that? How do you do that? And I find there's an answer to that. The best way to do that is that that witness must have access to that document wherever he is. So in Lagos, there are provisions in Lagos also that that allow witnesses to give evidence outside court. And then you front load the document. His testimony is also front loaded, all this testimony also before. Then the other side will cross-examine him. He has the document with him there. I've done it also in Lagos, where proceedings were taken before the CJ of Lagos right now, Justice Alugba, under Lagos law that permits the witnesses to give evidence. That witness also was in London, and through Zoom, we were able to conduct the proceedings, and the witness was cross-examined by the other side. So, and he has a document with him. But the aspect of the constitutional interpretation, which will also come to Supreme Court later, is as to that the section that says that evidence must be taken in public, where public will have access to it. But my take on that is that like the one we did in FCT High Court, one case recently at the FCT High Court before Justice Yusuf Baba Yusuf. We gave the codes to journalists also, so that they will be part of the proceedings. So you don't exclude the journalists who want to be part of the proceedings to participate in the proceedings.
Or any member of the public.
Or any member of the public who is interested. So I think we can find a way out on that by making it public, let the public be aware that you can access the Zoom or any technology you want to use. You can access it, you can watch it, and invite the member of the press so that they monitor, they see what is happening in court. So it will not be shrouded in secrecy